Hello viewers, welcome to the course on Economics and Law Part 1. Today we will discuss the concept in Law and Economics. This module provides a brief overview of the concepts of law and economics in terms of their nature and scope and how they are providing synergetic benefits to the students. In this introductory chapter, we will explore the fundamental ideas of law and economics as well as their theoretical underpinnings, historical evolution, and real-world applications. The main objectives of the module are to understand the concept of law and its nature and scope, to understand the concept of economics and its nature and scope, to learn about the synergetic benefits of law and economics. Overview of the law. Law is defined as a system of rules and regulations created and upheld by a governing body to control behavior within a community or a specific territory. Selman defined law as a body of principles recognized and applied by the state in the administration of justice. According to John Chipman Gray, the law of the state or any organized body of men is composed of the rules which the courts, that is, judicial organ of the body, lays down for the determination of legal rights and duties. The purpose of laws is to offer a framework for settling conflicts, upholding law and order, and defending the rights and obligations of both people and communities. They function as a tool for formalizing the rights and obligations of the government and the people or social impact inside a society. Law is an intricate and multidimensional notion that may be interpreted in a number of ways. Let us discuss the nature and scope of laws. Nature of laws. Laws are sets of guidelines that control how people behave within a community. Governments and other authoritative entities enact and uphold them in order to preserve law and order, administer justice, and safeguard the rights and interests of the people at large. Aspects of human relationships and governmental duties are covered by many categories of laws, including administrative law, criminal law, civil law, and constitutional law. Laws are dynamic and subject to change throughout time in response to shifting knowledge, social requirements, and values. Let us discuss about the scope of laws. Laws have a wide range of application and address many facets of society and human existence. Among the important domains covered by legislation are criminal law, establishes the penalties for crimes committed against the state. Civil law handles disagreements between the people or organizations and offers compensation to those injured by carelessness or other people's acts. Constitutional law defines people's rights and liberties as well as the essential structure of government. Administrative law makes sure government organizations follow rules and regulations by regulating their activities. International law deals with how countries relate to one another and offers rules for commerce, diplomacy, and settling disputes across borders. Laws cover all contract law, property law, family law, environmental law, employment law, intellectual property law, and many more topics. Different jurisdictions have different legal systems and sets of rules and regulations. Therefore, the extent of laws might differ as well. Let us discuss now an overview of economics. There are several definitions that encompass the core of economics, and there are many methods to describe it. A few typical definitions are as follows. Economics is the study of how people and communities divide their finite resources to fulfill their never-ending desires. The production, distribution, and consumption of products and services are the subjects of the scientific discipline known as economics. The study of economics examines how individuals make decisions to maximize their well-being in the face of scarce resources. Nature of economics. Economics is a social science that studies how people behave in relation to economic activity using scientific techniques. Economics is about decisions. It centers on the decisions individuals make to efficiently distribute their limited resources. Scarcity is a problem in economics. The core issue in economics is scarcity. While needs and wants are essentially limitless, resources such as time, money, labor, and natural resources are finite. Scope of economics. The scope of economics is broad and can be categorized into several subfields. Microeconomics. Microeconomics is the study of individual economic actors, including markets, individuals, and businesses. It looks at the choices these actors make about producing and consuming products and services. In microeconomics, supply and demand, pricing, consumer behavior, and market architecture are important subjects. Macroeconomics. Macroeconomics studies the overall state of the economy. It examines aggregate factors such as GDP growth, unemployment, inflation, and national income. Macroeconomists research the relationship between many economic sectors and the monetary and fiscal policies that might affect them. Public economics. This field of study looks at how the government affects the economy. It focuses on issues like public expenditure, taxes, and regulations from the government. Public economies evaluates how government actions affect the economy. International economics. This field of study examines how various nations interact with one another within the framework of the global economy. It covers subjects including global financial markets, balance of payments, currency rates, and international trade. Development economics. Development economics is a study of how economies grow and develop, especially in low-income or developing countries. It looks at what helps and does not help with income disparity, poverty alleviation, and economic development. Environmental economics. This branch of study examines how economic activity and the environment interact. It covers topics including sustainable development, environmental deterioration, and resource management. Behavioral economics. This field of study integrates knowledge from psychology and economics to comprehend how people's feeling and cognitive biases affect their financial decisions. Health economics. This field of study looks at how resources are distributed in the healthcare industry, covering issues like health insurance, funding for healthcare, and the affordability of medical procedures. Let us now discuss about the introduction to law and economics, a synergy of two disciplines. Law and economics, a branch of economics, is a multidisciplinary approach to comprehending the legal system and its impact on behavior in people. It looks at how economic concepts may be used to analyze the law and determine how laws and regulations impact people's ability to make decisions for themselves and for society. In recent decades, this interdisciplinary discipline has grown significantly, revolutionizing the way we approach public policy, the legal system, and resource distribution. In this introductory chapter, we will explore the fundamental ideas of law and economics as well as their theoretical underpinnings, historical evolution, and real-world applications. Early roots of law and economics. Law and economics have their origins in prehistoric societies when legal systems were shaped by primitive economic theories. We will explore how early cultures dealt with problems like contracts, torts, and property rights using economic concepts. Economic concepts impacted legal systems by addressing matters like property rights, contracts, and responsibility in ancient civilizations like the Babylonian Code of Hammurabi and Roman law. These early legal and economic origins may be found in these legal systems. Different civilizations have incorporated economic ideas into their legal systems throughout history, demonstrating an early awareness of the link between the economic efficiency and the rule of law. These historical effects laid the groundwork for the modern multidisciplinary approach that looks at how legal rules and regulations affect resource allocation and human behavior through the prism of economic analysis. Even though the formal subject of law and economics just came into being in the 20th century. Introduction and scope of law in economics. The scope of law in economics is vast and continuously evolving to address the complex economic challenges of contemporary society. Regulations and legal frameworks are essential in determining market dynamics, economic behavior, and overall performance. As a result, both academics and decision makers may learn a great deal about the interaction between law and economics. In economics, the field of law is quite broad and covers many facets of economic activity. An interdisciplinary discipline known as law and economics studies how legal frameworks and regulations affect the conduct and results of the economy. The following are some significant fields where economics and law meet. Let us discuss them briefly. Property rights. Laws are essential in creating and protecting property rights, which are a basic component of economics. The operation of markets and resource distribution depend on laws pertaining to property ownership, land use, intellectual property, and contracts. Contract law. The foundation of business dealings is contract law. Trust and predictability in business interactions are largely dependent on legal frameworks for contract enforcement, remedies for violations of contracts, and the function of contract law in promoting economic trade. Antitrust and competition. These laws are intended to encourage competition and prevent anti-competitive behavior in the marketplace. They assist in preserving fair competition for enterprises, averting monopolistic practices, and safeguarding the interests of customers. Market regulation. In order to guarantee fair competition, consumer protection, and public safety, governments frequently regulate a variety of markets and sectors. Regulations pertaining to finances, the environment, and product safety are a few examples. Taxation. A key element of economic policy is the tax code. They control the creation and distribution of government money, which has an effect on investment choices, economic activity, and income distribution. Labor law. The dynamics of the labor market and the welfare of employees are influenced by labor relations regulations, which include minimum wage legislation, workplace safety requirements, and collective bargaining rights. Intellectual property law. This field of law encourages creativity and the sharing of information by safeguarding inventions, innovations, and creative works. International trade law. Trade laws influence cross-border movements of products and services as well as international economic exchanges. These laws include tariffs, trade agreements, and dispute resolution procedures. Consumer protection. Legislation covering a range of economic interactions such as product safety, fraud prevention, and fair advertising practices is aimed at protecting the interests of consumers. Environmental law. In order to protect natural resources and ecosystem services, environmental rules impose restrictions on pollution, resource exploitation, and land use. This helps to handle economic externalities. Bankruptcy law. In cases of financial difficulty, bankruptcy laws influence the distribution of assets and obligations by offering a framework for handling insolvent people and companies. Monetary and financial regulation. Laws that are essential to the expansion and stability of the economy govern the stability of the monetary system, central banking, and the financial industry. Competition policy. Competition policy, often implemented through government agencies, aims to prevent anti-competitive practices, promote consumer welfare, and maintain efficient markets. Welfare and social safety nets. Laws related to social welfare programs such as unemployment benefits and social security have significant economic implications by influencing income distribution and economic security. International economic law. This field includes treaties and agreements governing trade, investment, and financial relations between countries, shaping the global economic landscape. Now, let us discuss about economic analysis of law. The multidisciplinary area of law and economics uses economic theory and concepts to analyze, comprehend, and enhance the legal system. Its core tenets are the significance of incentives and efficiency. We will go into these important ideas in this lecture and consider how they affect the law and policy making. Efficiency. A fundamental idea in both law and economics is efficiency. It entails optimizing the welfare or utility of society as a whole, using resources as efficiently as possible, and ensuring that resources are distributed to their highest value applications. Efficiency may be categorized into three main areas: allocative efficiency, productive efficiency, dynamic efficiency. Let us discuss them briefly. Allocative efficiency. This term describes how resources should be distributed in the best possible way to benefit society as a whole. It is achieved when goods and services are produced and consumed in quantities where the marginal cost equals the marginal benefits. Here, marginal cost is the cost of producing one more unit and marginal benefit is the value of consuming one more unit. This concept indicates that legal laws and regulations should try to distribute resources in a way that maximizes society's welfare in the context of law and economics. Productive efficiency. The goal of productive efficiency is to produce goods and services as cheaply as feasible, while making sure that resources are utilized effectively throughout the production process. It promotes the most economical use of resources, which lowers costs and increases consumer surplus. This suggests that in the context of law, the legal system ought to work to keep the expenses of settling disputes, upholding arrangements, and making decisions about cases to a minimum. Dynamic efficiency. Dynamic efficiency considers how economic systems might change throughout time. It highlights the significance of technical advancement, creativity, and adaptability to changing conditions. According to dynamic efficiency in law and economics, a system that promotes development and innovation should be supported by the legal system by safeguarding property rights, upholding contracts, and promoting market competition. Let us now discuss about the cause theorem and property rights. The cause theorem may be used to comprehend how efficiency functions in the real world within the legal system. This theorem, which was put out by economics Nobel Prize winner Ronald Coase, has had a significant influence on both law and economics. It revolves around the concepts of property rights and transaction costs. The Coase theorem states that rational people would always bargain and swap resource rights in order to arrive at an optimal solution when there are no transaction costs. This implies that voluntary bargaining can lead to optimal resource allocation independent of the original assignment of property rights. Consider a simple example. Alice and Bob are the two neighbors and they have different uses for their land. Bob's peaceful home life is disturbed by Alice's noisy factory. Alice and Bob can negotiate a solution if there are low transaction costs. That is, if there are few expenses involved in the negotiation process, an agreement making and contract enforcement. For example, Bob may allow the factory noise in exchange for a fair payment. The cost theorem emphasizes the significance of low transaction costs and property rights in attaining efficiency in this manner. However, in the real world, transaction costs are rarely zero. Negotiations can be complicated and legal systems exist to reduce these transaction costs and enforce property rights. The legal framework plays an important role in shaping property rights, defining liability rules, and facilitating efficient exchanges. In the above example, if transaction costs are too high, Alice and Bob might not be able to reach an agreement. In such cases, the legal system can intervene by defining property rights and enforcing them, ultimately pursuing an efficient outcome. Efficient breach of contracts. Efficiency is important in the context of contracts and contract law as well. One important idea in this field is the concept of an efficient breach. An efficient breach happens when one party to a contract violates it in order to maximize their own benefit as well as the welfare of the society when presented with fresh knowledge or changing circumstances. For example, suppose Company X has a contract to purchase goods from Company Y, but due to some unforeseen events, it becomes significantly cheaper for Company X to buy the same goods from another supplier, say Company Z. In this scenario, an efficient breach by Company X, though resulting in a contract violation, may lead to a better allocation of resources in the economy, benefiting both parties in the long run. The concept of an efficient breach admits that not all contract breaches are harmful or inefficient. It recognizes that contractual performance is not an end in itself. Rather, it is a means to allocate resources optimally and promote overall welfare. This idea is particularly relevant when considering remedies for contract breaches and the broader role of contract law in facilitating efficient exchanges. Property rights and externalities. One of the most important components of the cost theorem is property rights, which are essential for mitigating externalities. Externalities are the side effects of economic activity that have an impact on parties who are not actively engaged in it. It can be positive, that is beneficial, or negative, that is harmful. It is important to assign and enforce property rights for the impacted parties to resolve externalities effectively. For instance, in the case of pollution, if property rights to clean air are well defined and allocated to the affected parties, that is, those experiencing the negative externality, the polluting party will have an incentive to reduce emissions to avoid violating property rights. the legal system through tort law and environmental regulations often defines property rights and liability rules to internalize externalities. It aims to balance the rights of those who produce externalities, that is pollution, with the rights of those who suffer from them. This approach ensures that economic actors take into account the full costs and benefits of their actions, leading to more efficient outcomes. Conclusion. To sum up, laws are an essential component of human society that are designed to safeguard rights, create and uphold order, and offer channels for settling conflicts. They cover a broad spectrum of topics and are influenced by the political, historical, and cultural context of every community. Understanding the types, purposes, and nature of laws is essential to comprehending the legal frameworks that control our daily lives. Economics is a critical subject of study for comprehending and addressing numerous economic and societal challenges, since it plays a crucial role in influencing company decisions, individual choices, and governmental policies. The foundational principles of efficiency and incentives form the basis of law and economics. Efficiency involves the distribution of resources, productivity, and flexibility within economic systems, directing the creation of legal norms and regulations. The cause theorem, efficient breach of contract, and property rights assignment are important examples of how economic analysis is utilized in the legal system to accomplish these efficiency objectives. It is imperative for policy makers, legal scholars, and practitioners to comprehend the interactions between these concepts in order to advance a legal framework that maximizes both economic efficiency and human welfare. That's all for today's lecture. I hope this has raised your concerns about this important topic. Have a nice time. Goodbye.